cashews there. Raw cashews. I love cashews. Well, I like cashews. Hi, how y'all doing? Good to see you. I'm back. It's lovely, God glorious, victorious day here. And a few years back, a friend of mine was talking with a lawyer about a house and who owns the house, so on and so forth. And the short version is this: the lawyer acknowledged or admitted that my friend did not own the house. In other words, the lawyer actually said, "We know you don't own the home, but who gets the money?" And there it is. Who gets the money? And technically speaking, the trustee should get the money. However, if you've claimed your securities and stuff, and it's all the fruits of your own securities, then there's no benefit there coming from a third party, or there's no benefit from it's your tree, it's your fruits. There's no benefit. But really what I wanted to talk about today is we have the government regulations regarding securities, what the governments will accept as a security. And I'm talking about, in particular, promissory notes, promises to pay, or bonds. A bond is a mere promise to pay. Do your own research on that, you'll see that. And so with these securities, the government is looking for certain things. And the first thing you'll notice, if you're doing any due diligence, don't take my word on any of this. So let me just do a little screen share here. Now this, before I do this then, this is regarding security for debts due Her Majesty the Queen. So this is, any realms that are dealing with Her Majesty the Queen. And these regulations make up part of the Financial Administration Act. And of course, it's a Department of Finance. It sets out all the income tax code and regulations, legislation. It'd be the same in every country with respect to securities. And what we're trying to do here now, though the title of this is Security for Debts Owed to Her Majesty the Queen, we don't owe Her Majesty the Queen is not the point here. The point is, what does the government accept or see or need to see in order for security to be a security in their eyes, to be not be a worthless piece of paper? And I did say that Winston Trout unfortunately found himself in jail, and that is because he didn't secure the foundational security. But it's understanding the significance of that foundational security is paramount for people here, I think. It's a exceedingly important document. That registration of birth I'm talking about. I'm talking the original that the government has possession of. Best we'll ever get is a copy of that, or a certified copy of that. And some people are struggling with that. But if you have a birth certificate, that's proof enough that that document exists. That registration of birth security exists, and that they have it. So as I mentioned, Winston was issuing securities, but he didn't have an underwriter. He didn't have a surety or a guarantor. Without that foundational document, there is no surety. That's the surety. Understand this, that is the surety, not you, not me. You can be presumed to be that, and that's what's been happening to people. But it's that registration of birth document, this document right here, the original the government has, that's the surety / guarantor. Your estate, right? That's the property. You notice a lot of most of your documentation here, speaking for Ontario, any documentation respecting a property has this name on it. So Winston, because he didn't have that surety / guarantor, this secured or didn't identify it in any way as the ultimate security. And again, this is in trust. Government's holding this in trust, so they already have the surety. If you get from, follow me here now, / guarantor. And it is the ultimate security, and that's from the express trust under the common law, something that President Roosevelt had commissioned an investigation into businesses that run by in the form of trusts, in common law trusts versus corporations that lawyers were bringing in. And the dispute back then was that the concern was that although businesses that were managed like a trust, an express trust under the common law was managed by trustees, there was basically zero bankruptcies, and the reason for that is the trustees are fully accountable. Whereas in the corporate thing, the corporate people can hide behind the corporate veil, so the corporation goes bankrupt, and that was causing a lot of financial burden on the public. So that's a very interesting read, but it's very clear in there that the estate is the ultimate security, and that's that the government is holding here. So Winston Trout didn't have this secured, so all those instruments that he was issuing, I shouldn't say just secured or identified. Different ways to secure it or identify that it's your security, without putting limitation on that in the thinking here. So because he didn't have that, all of those securities he issued were worthless. So I'm going to show you, give you a screen share here. Just let me pull that thing up. See here, this is put out the Treasury Board of Canada in conjunction with the Ministry of Finance Canada, Security for Debts to Her Majesty regulations. I just want to go right down to the last, it's a very small regulation. Security. For the purposes of these regulations, only a charge in favor of Her Majesty on the existing or future personal or real property of a debtor, or on the existing personal or real property of a person who is a surety or guarantor of the debtor, shall be deemed to be a security. And there it is, shall be deemed to be a security. So we know who the surety is. We know who the surety is, what the guarantor is. They have this already. And so when we issue promissory notes, that's what I keep saying, is your promissory notes, if you don't have this in the equation, they're worthless and you'll be into problems legally. Ask Winston Trout and then the others who played the game without having that document secured. And I tell you, for us, it was a revelation when I heard that that was a security. That for me was the missing link. And I'd understood securities, but I never, just didn't go cha-ching on my mind. So, and you know, these regulations to make it clear. And then in the case of a bond, if a bond is, the government accepts a bond at 95% face value. So it's just a discount they're doing on that automatic, really. So a $100,000 bond or promise to pay is worth $95,000 to them. So no big deal. We don't care. We're giving them a blanket one anyhow. With a grant of a signature. You didn't hear that here. So just wanted to do a little teeny blurbage on that so that people are clear here. If you I wouldn't be doing any securities. And again, you look in your securities legislation to know what a security is, but here in what we're talking about with respect to settling the accounts as a promise to pay, that security, which as I've shared in previous videos, is Section 13 of the Securities Transfer Act for Ontario, Canada, and it'd be coast to coast really. And also in UCC Article 8, also has it 8103D3. So it's UCC Article 8103 D3 in Roman numerals. I did talk about the previous video, I think, but one other thing here, I think I've touched on it previously, but I just thought it might be good to have fitted into this conversation here, and that is the trade in respect of securities. Now, this is basic banking. Trade in respect of securities means any sale or disposition of securities for a valuable consideration. And if you understood what I just said there, you could call the bank's bluff. Yeah, you can call the bank's bluff. If you think about how could I call the bank's bluff, you give the bank a promissory note. They're calling it a loan, but it says here sale or disposition for a valuable consideration. Maybe they purchased it. Maybe I should tell them they purchased it. There is no debt. See what they say. Just wanted to do that short thing here on the securities and what the government's looking for so that they're not considered worthless pieces of paper. So just put things in perspective, and there's more lingo to this. Don't just do this because you're seeing this here. I highly recommend you don't, but you properly identify this in your connection to it. Otherwise you don't have any standing. It could have, blown down the street and you just found it. You got to keep in mind that's, in a lot of these outfits, they do have a duty to make sure they got the proper individual in front of their face. And so you want to make that connection, and quite rightfully so. It's, there is a lot of fraud going on out there, and I'm not saying government's not part of it, but they're not necessarily asking for identification to incriminate you. They want to make sure they got the right account. That's how I see it. So this, for example, it was properly identified and your connection here, and attach a promise to pay to it. Attach the security to this security, the surety, the ultimate security. kind of see where I'm going here. Just one little addendum I wanted to add to this video since we're here. This part 17. As I mentioned, last little bit there in the previous part of this video about this being the surety / guarantor underwriter, and make sure negotiable instruments, your security is good. Well, this is what I mean by a banker's acceptance. When you appear in court, the court has put up securities on the basis they're doing it on your behalf, and they are attaching these securities to this unknown to you. This is why we say the estate doesn't consent. See, so now they can't stick it to there and their paper's worthless. Worthless. But that's, so you make an appearance in court, they've already put up securities, bonds are leveraging against this. And that's what makes their securities good. And they can securitize and all so on and so forth and get their money now. And it's all the debt posted to your estate, the estate here in trust. So like I say, as much as we can stick a security / note to this, and this surety here makes it good, security makes this security good. In other words, this is backing this. And yes, you and I are behind that, but that's two ways we can be behind that as the, let's say the trustee / quasi surety, or we could be behind that as the grantor. You get to decide. I get to decide. But then otherwise in a court case, for just an example, but you appear in the court case, 3 types of appearance, and then that gives them a banker's acceptance, which is basically you're saying, yeah, go ahead and put up my estate surety security to back up your court securities. And there it is. That's why I say you get your head wrapped around this stuff and renew the mind a bit and let go of a lot of old concepts that are really redundant, and still people want to try to blend it in with things they've learned, and that's fine. Not for me to tell them what to do, but it comes down to very basic, simple principles. Once you see those principles in action, and you can see them all over the place, and you go, this is really simple, because it's the same approach. It's the same thing going on in every transaction, essentially. And anyhow, a little more food for thought for you is there. And on that note, I leave you. I thank you for listening. And until next time, God bless, love you, peace and love. And I pray for the planet, pray for God to do his work through the good people. God bless you. I bid you adieu. Take care.